Hi and Assalamualaikum, Ms. Azlin. Today our group will present the topic that has been given to us, which is conditions that lead to trade disputes in Malaysia. In this video, there are 4 presenters that will present according to their part.
Trade dispute is defined as a dispute between an employer and his employees relating to employment or non-employment, the terms and condition of employment, or the condition of the place of employment. Trade dispute exists when both parties, their employers or union, and their employees or unions fail to reach mutual agreement on employment or non-employment issues. In Malaysia, the Department of Industrial Relations Malaysia JPPM is a department that plays a key role in helping to resolve industrial disputes in order to preserve and maintain industrial harmony in the country. Industrial harmony is the most important precondition that must exist if the country wants to strengthen the stability of the economic system and to ensure that the industrial relation system that is being practiced is able to face the challenge ahead. As a result, it will automatically assist the country in achieving greatness and glory without being disrupted by any collective bargaining or industrial disputes that might endanger the country's economic stability.
The first condition that leads to trade dispute in Malaysia is the refusal of any party to commence collective bargaining. Collective bargaining is a method for tackling work environment issues. The meaning of collective bargaining is the interaction where a group of employees collectively negotiate with the employer. However, a condition relating to the refusal of any party to commence collective bargaining is because employers and employees cannot reach a mutual agreement in certain situations, such as relating of wages, working time, and so on. Nowadays, the common issue that lead to dispute between employers and employees are due to the wages issues. For example, the wages received by employees do not correspond to their working time. This can be seen in the case of J&T Express. In this case, the employees in the delivery department are not satisfied with their employer because the payment of wages does not correspond with their working time. So regarding this case, a few employees are sharing their disappointment with the administration by throwing client packages in the factory. If the employer can't tolerate with their employees regarding this matter, it can be categorized as the refusal of both parties to commence collective bargaining. The impact of this condition is it can give the bad reputation of the company image. Company image and reputation are significant parts of their perspectives outside constituents whole of organization. The bad reputation of the company image can be related to the bad performance of the people in the organization itself. As mentioned just now, at the point of refusal any party to commence collective bargaining, employers and employees cannot meet mutually agreement in a certain situation, which is in giving payment of wages among workers. It is because employees feel dissatisfied with their salary provided by their company. If this matter continues, it could cause the company itself to lose quality employees. As a result, they are not committed to completing their work and do not put in the best effort to make the company successful. This behavior shows us they contribute bad performance as a sign of protest or dissatisfaction towards their employees. When it comes to the performance among employees, the entire business may be affected by damaging the company image and struggle to reach certain goals in the company. It is because when intentional wrongdoings by company does itself or employees that lead to the company having a bad reputation. However, it is important to employer value their employees because they will be more dedicated to serving the company in an ultimately great manner.
Conciliation is known as the process of resolving trade dispute with the help of a third party. In conciliation, the conciliator plays a relatively direct role in the actual resolution of dispute and even advise the parties on a particular statement by making recommendation for settlement. To hold conciliation procedure, one of the party must offer the other a formal invitation. The invitation will be considered unexpected if the parties does not get a response within 30 days of sending it. The conciliator may require that each party submit a written account of the pertinent facts in the case. A written statement from both parties must be submitted to the conciliator. The parties were also invited to provide written statement to each other and the conciliator. The last procedure is known as administrative assistance under Section 68, which stipulates that with the approval of the parties involved, both party and the conciliator may request administrative assistance from relevant organization or people. There are examples related to conciliation held in courts. Although the following awards relate to employee dismissal and not trade dispute, the issues related to the matters discussed during the conciliation season are the same. The example of case is case of Norizan Muhammad Tahir v. Takaful National Berhad 2010.
Alright, allow me to continue our discussion regarding the conditions that often occur in the workplace environment. Next, we will discuss about the condition that is about the disciplinary action taken by an employer, which are considered as unfair or unwarranted. This condition is well related toward the disciplinary action that can constitute as a reprimand or action to a correction which serve as a response to a case of employee misconduct, breach of rules, or poor performance. However, it still needs to be seen and depends on the level of the severity of the case because each disciplinary action is different and it can only be applied after analyzing the suitability of any case that has occurred itself. Consequently, among the list of disciplinary action that can be adopted include verbal warning or a written warning, poor performance review or evaluation, performance improvement plan, demotion or salary, and not to forget also is the termination of an employee. In the meantime, such action that can be triggered when it involves poor performance that is highlighted by an employee himself, where it has become normal if there are any shortcoming or unintentional mistake. However, if a decrease in a person's work performance is too frequent, then it will invite something that does not make sense and the issue will be raised. There are also situations when a source of constant conflict exists among the employees themselves. Such a thing can happen assuming there is a clash or disagreement between two or more parties. Highlights from the above cases which are classified as an offence that should be given a lesson. Therefore, among the appropriate action that can be taken against the offenders include such as by holding a formal meeting involving employees who are committed offences. At the meeting, the management should state the offences so that the employee knows every accusation made against him and professional attitude should be practiced so that no issue arises such as the issue of blaming each other. Other than that, there are several types of employee disciplinary action that can be applied after the failure faced by the management in the aspect of the initial handling of an issue that arises. Such action that can be include suspension of unpaid employment, temporary deduction of employee salary, termination of employee service, devaluation of employee power or rank, relocation, and even loss of employee privilege. The following are the action that can be taken against an employee who commit an offence, and each action that is to be taken against the offender must be abbreviated to determine the level of case so that it can be conducted fairly without raising issues such as management imbalance. The employee is only due to the action taken is unreasonable and not appropriate to the case at hand. As discussed on the disciplinary action imposed on employees who commit offences, it will also have an impact on the action taken either in terms of goodness or otherwise. For the positive aspect that can be highlighted as a result of the action taken, it is able to provide a clear explanation of the consequence of not complying with the employer's rule or not meeting expectation. That way, employees will be more vigilant with any behavior shown so that it does not go against the existing rule laid down by the employer. In fact, it also provides an opportunity for employers to be more consistent and fair in imposing disciplinary procedure for different employees and appropriate to the case. However, from the point of view of the disadvantage of the application of disciplinary action to employees, including in situations where it shows that such a policy is seen as an inflexible matter, this is because the HR as well as the management as the manager on duty need to make a call for consideration when there are elements that divided from the progressive measure, which may be necessary when considering all the circumstances.
Next is arbitration. Arbitration is a contract-based technique of binding dispute settlement. To put in another way, a party's right to refer a dispute to arbitration is conditional on the existence of a written agreement, the arbitration agreement between them and the other disputants, that the subject may be submitted to arbitration. The arbitration agreement will almost certainly be included in the document that details the business transaction circumstance if the parties agree to arbitrate. Despite the fact that there are both kinds of alternative dispute resolution, arbitration is not the same as mediation or conciliation. According to arbitration cases, the further decisions, which is High Court decisions on whether to grant anti-arbitration injunction or not. Federal Investment Corporation Sdn Bhd versus ZAINURI, Prominent Sdn Bhd 2020, MLJU 1465 with grounds of judgment date 23 September 2020. Federal Land Development Authority and Anwar Vita Sri Haji Isa bin Datuk Haji Abdul Samad and ORS 2020 MLJU 1587 with grounds of judgment date 25 September 2020. Next, Master Mulia, which is Federal Court, sets out the setting aside rules of breach of natural justice. Master Mulia Sdn Bhd v. Sigur Rus Sdn Bhd 2020 12 MLJ 198 with grounds of judgment date 27 August 2020. The decision established essential guidelines for overturning an arbitrary ruling based on a violation of natural justice. Next is arbitration. Arbitration is a contract-based technique of binding dispute settlement. For
the conclusion, a trade dispute occurs when an employer and his employees argue over the terms and conditions of employment or working conditions, unpaid work suspensions, temporary salary reductions, the termination of employee power of rank, relocation, and even the loss of employee rights are examples of such actions. Overall, they were used as an example of YAACOB express cases where poor worker performance and disengagement between bosses and employees may make a company's brand or image look bad to the public. To put it another way, a party's right to bring a dispute to arbitration is conditional on the existence of a written agreement between them and the other disputants. That's all from me. Thank you.